Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers with your hosts, Ben Siders and Kirk Damon.
And welcome back to A Lawyer's Guide to the Galaxy, the podcast that asks interesting questions that don't have any answers with your hosts, Ben Siders, that's me, and the other guy is Kirk Damon.
That's Kirk, as in the captain of the Enterprise.
We are intellectual property attorneys and certified geeks practicing law in St. Louis, Missouri. You can find me, Ben, on Twitter at Benjamin Siders. You can find Kirk at KirkDMN, and you can find the podcast at LGGPod. In a shocking turn of events, we have two back-to-back episodes released in relatively quick succession.
This summer was kind of rough on us for getting together and doing
posting. The summer seems to have been that way most of the time. But we have a topic today that we've been wanting to talk about for a while, and we finally sat down and got around to it. The case is Hanagami versus Epic Games, a Ninth Circuit Court of Appeals decision that we think was issued late last year, November of 2023, concerning a rarely litigated area of the Copyright Act, choreography.
Yep, and the reason we're talking about this is, of course, Fortnite.
So if you've ever played Fortnite, I haven't played Fortnite. I never played it. Have you played it?
I haven't played it. My son's played it.
Yeah, so it's how would you describe it, Kirk?
It's a massive multi-person shooter game.
All right, a shooter game. And then in the game, you have like an in-game currency where you can buy, I take it, skins and things like that.
Yep.
But one thing we know you can buy is emotes, which is where you program your character to go through a little choreographed routine. If you've ever played World of Warcraft, we have these in Warcraft as well. A lot of games have them. You can type in like /wave and your character will wave or blow a kiss or something like that. Interestingly, World of Warcraft also has a bunch of dance routines that the characters will do. Every race in Warcraft will do a dance. So the orcs will do the MC Hammer parachute pants dance. The ogres will do Chris Farley's Everybody's Working for the Weekend Chippendales routine from Saturday Night Live. There's like a Michael Jackson, Billie Jean thing that I think the Night Elves do. So that's all in there. They have not been sued, to my knowledge, for that by anybody.
Now, they may have also licensed it. We don't know.
Well, that's the thing. They may have licensed it, or it may be because, unlike Fortnite, you don't have to pay anything to get access to those. If you've bought the game, your characters can do those dance moves. Fortnite is not like that. To get access to at least the emote at issue here, you must pay some amount of virtual in-game currency, which according to the case is about $5.
So many games now have essentially these aesthetic improvements that you have to pay for. I mean, skins are by far the most common. Any game you play in, there's something which will alter the appearance of your character, some of which you have to pay some form of in-game currency, which is convertible to real currency. Now, many of these, but there are a lot of these games, you have things that are, at least convertible into a real dollar payment in any practical way.
And these are vanity purchases. I mean, I've played games like this, and you want to look cool in the game, just like in real life. So you pay the in-game currency for things that it's a way for the company to make some money without the pay-to-win meme being applied to you. That way you can bring in revenue by giving people aesthetic things that don't actually change gameplay function.
And let's face it, a lot of these things is stuff that has always been in game. I remember in, Doom and Quake, you just type it into the chat thing.
Or you position your character in a suspicious area that kind of makes it look like you're doing things that maybe you're not actually doing.
Yeah, same idea. I mean, it's those kind of things sort of with it. So we've always had this desire in some respects to, for lack of a better term, taunt the enemy.
Yes. That's what this is all about,
that's
right?
What this is all about.
Dunking on people on the internet.
Which we all know is the purpose of the internet, is to dunk on others. It's things which people think are fun to have and which make them, in some sense, I like your term, sort of cooler, at least in their own mind, in the game.
So here's what happened. The plaintiff is a guy named Kyle Hanagami. I've never heard of Mr. Hanagami. I don't think Kirk has either.
Nope.
But his credentials are impressive. He has worked with Jennifer Lopez, Britney Spears, Justin Bieber. He's been on the faculty at 3 of the top dance schools in the Los Angeles area. He has partnered with globally recognized brands like Nike, Disney, Google, Netflix, and so on it goes. Over 957 million total video views for his YouTube channel, with more than 4.5 million YouTube subscribers as of the date of this decision. So kind of a big deal.
But if you know anything about dance, you almost certainly heard of this guy.
Would not be surprised if you've heard of him. So he puts out a video in 2017. It's a 5-minute-ish long video to the song How Long by Charlie Puth? I don't know. Yeah. The choreography has about 480 counts of choreography in the song, 96 counts repeated by 5 different groups of dancers. 36 million views. Lots of people have seen this video.
Yeah, this is a well-known dance. I probably would recognize it if I saw it. It's a well-known dance.
So what happened is Epic released an update to Fortnite, which included a new emote called It's Complicated. And Hanagami claims that this emote basically copied the most recognizable portion of his choreography from the How Long video, which consists of 16 counts of movement, 4 of which were copied directly from his work. And I think the lower court later said it's about 2 seconds of we'll call it animation in the game or choreography in the video. So it's not a huge portion, and just in terms of the size relative to the 5-minute long video.
Well, and part of it's just the nature of what we have here. These emotes have to be relatively quick. Obviously, if your character performs a 5-minute video, you probably lose the game. So we have 2 objects of very different length, and I think that's important to keep in mind. Just that's what they are. It's not that they're done on purpose to be different lengths. The nature of what they are is inherently of widely different
emote
length.
has to be reasonably brief.
Yeah.
So anyway, this emote was priced at 500 V-Bucks, I guess is the currency. Don't love that name, but at the equivalent of $5.
Then you realize that all the Fortnite people are thinking we've lost all of our geek cred by the end of this.
I will acknowledge Fortnite is one of the things I've never gotten into. On purpose. I'm worried that if I get into it, I'll fall.
Be too into it? Yeah, exactly. That's the same problem.
Okay, so 2021, Hanagami applies for a copyright registration for the video, the whole video, and we should be more specific, not for the video itself, for the choreography as represented by the video. And this is common in copyright. A good analogy is musical work. So when you think of a song, you're probably thinking of the recorded version of the song you've heard on the radio or that you have on your iPod or whatever. Do people have iPods still?
Yep.
Okay. You're thinking of that version. That is a separate copyright. That is a sound recording, which is separate from the underlying musical work. The musical work is the song in the abstract, and the sound recording has that song on it. It also has a sound recording. So here we have, I guess it is a music video that also has the choreography in it. What he was trying to copyright is just the choreography, not the video itself.
Yep, and I think this is important to keep in mind. It's one of those places where we're going to have trouble potentially making sure we stick to common terminology.
Because the term's not defined either. The Copyright Act doesn't define what choreography is.
And we're going to try to stick to it as much as we can, is that choreography and dance are different. Even though we've been referring to these things as dances, there's going to be a big distinction here. Choreography and what was submitted as a music video are different.
Yeah.
So when we talk about the idea of what is copyrighted here, you can copyright choreography, and what was submitted as the copyright specimen example is not just choreography. It has other stuff in it.
So anyway, he gets the copyright. Whether or not it's valid is not at issue. He then files suit against Epic, arguing that It's Complicated infringes. Epic filed a motion to dismiss at the pleading stage. We should explain what that means.
One of the things that we need to go into in this case is a little bit of exactly what the procedural posture of it is.
So when you file a lawsuit, we should start with, you write a complaint, which is basically a list of factual allegations about what has happened so far.
Yep.
They may turn out to be correct, they may not. But for immediate purposes, the court just has to assume it's all true until we get into discovery.
What a motion to dismiss is, if everything in the complaint you say is 100% true, the court still can't give you any relief because you have no legal claim. This is the court's very initial way of basically a filter to say, look, this court can't help you.
Yeah, and that's exactly what Epic said. They basically argued that, look, even assuming we took anything like he alleges, what was taken is so small and so insignificant that as a matter of law, it's not copyright infringement. And the district court agreed. And they said, yeah, when you look at this, there's like a couple of individual poses from the original 5-minute video that Epic used. Those individual poses are not copyrighted. The overall choreography is, nobody disputes that. You've got the registration. Yeah. But those specific individual poses are not copyrighted. And so what has been infringed here is not anything that's protected by the law.
And I think it's important to point out here, the reason we have this sort of reasoning from the district court is basically the court needs to specify why it's not allowing this case to continue. So they have to decide on the motion. They have to issue a decision that says this is the reason why we decide on the motion to say this person doesn't have a case. So that's basically the idea, is he's looking at it and saying, we have your complaint. I've read your complaint. I take everything in your complaint to be true, and guess what? You still lose.
Basically, you only need a jury if there's a factual dispute. And the judge is saying, well, assuming there is no factual dispute, you're still wrong. So that's it. Also of note, the district court, part of their reasoning was that the two works contain a series of poses, but they say they're performed in different settings and by different types of performers, which jumped off the page at Kirk and I immediately because we were like, well, what difference does that make?
Yeah, that's not choreography.
That'd be like saying, well, as long as somebody else performs Let It Be, I'm not infringing any Beatles copyright.
Yeah,
That's clearly not true.
Or if I wrote Gone with the Wind in a different font, it wouldn't be an issue.
Clearly not true. So that seemed like an odd thing for them to say. So Mr. Hamagami appeals to the Ninth Circuit, and they reversed, and we got one of the very few decisions we've ever gotten on how choreography works. And this is why we wanted to talk about this, because the court kind of dances around a little bit some of the dances around a little bit some of the philosophical issues that Kirk and I often run into when talking about copyright, which is that, in a sense, everything we create is ultimately a gestalt of other things. So at what point have you assembled a gestalt that's something new and different and entitled to protection, and how much of that does there have to be, and how much has to be taken?
And I'm going to take it even one step further and say, right now we're very into the creation of gestalts, and exactly what does it mean when we're talking about AI. And large language models.
It's not exactly what it's doing, right?
Because that's arguably exactly what they're doing. They are creating something which is much more complex, and the question with it is that unique? Is that a sort of work of authorship? What does it mean to be human? To take all of these pieces that are out there and put them together into something. And in some sense, what we're getting at with this is ultimately a definition of what is creativity.
Yeah.
When we talk about intellectual property law, that fundamental question has to underlie all questions of intellectual property law, because we're designed to protect creativity. In some
and in a sense, what does it mean to be an author? Like, we sometimes think about like splatter paint and things like that, or I see these YouTube videos where people set up elaborate contraptions to cause a painting to be produced using like gravitational principles. You put a bucket full of paint, you poke a small hole in the bottom, and you turn it loose on like an elliptical pendulum, and it produces a spiral graph, basically. What did you contribute to the authorship? You're just relying upon a natural phenomenon.
But then there becomes the question of like, you chose the color of the paint, you chose the size of the hole,
how hard to push it,
And one of the things that you kind of seem to get into this is the concept that how much of creativity is simply the sheer number of variables that you control. So what we see here is a court doing, I think initially in this district court question, because of this argument in the appeals court, because the district court looked at it and said, we find too little similarity. There's just too small of a pieces. Them kind of looking at it and going, that may be true, but what are the small pieces that aren't coverable, and how it's the sort of minimum number of these we need to put together for it to become a choreographic work.
And in particular, has the plaintiff alleged enough to overcome that? Like, is there enough here that if we assume that he's right, should this be disposed of as a matter of law at this point, or should we give him a chance to make his case, get into discovery, and maybe this gets disposed of on summary judgment instead?
Even if he can prove this was entirely copied, it's not enough for it to be copyrighted.
Maybe the way to say this is, in an appeal in this posture, the Ninth Circuit is looking at whether the district court applied the law to this case incorrectly.
And they're really doing it in the idea that said you should have given them a chance to make more arguments.
Let's see how they got there. They started off by trying to figure out what exactly is choreography in terms of a legal definition. And we deal with this a lot in the law. There is no definition in the statute for choreography.
Well, I think it's a great word. We all know what the word choreography means.
And they point out that the Copyright Act doesn't have a definition. Interestingly, it also does not have a definition for musical work, so it's also undefined. But they also go to pains to say, we looked at the legislative history to see what Congress was thinking when they added this, and Congress specifically said in passing this law, everybody knows what it means, so we don't need a definition.
Exactly, which I think is kind of great, because again, I mean, the immediate thing I jump to is, if you guys have been to any form of, musical theater, or, and recently in conjunction with it, and you've read the bios in the back, there is a person who is the choreographer. What exactly did they do? That's what the court first starts struggling with.
One of the things that was really interesting is that they looked at the Copyright Office's publications on this and pointed out that there's choreography and there is dance. And choreography is a subset of dance. But not all dance is choreography. And they specifically said that things like social dance, which I'm not sure what that means. Maybe it means like traditional dance or folk dance. I'm not sure. But that is not choreography. They say here specifically, choreography has to
be planned.
Yeah, that
Whereas,
definitely is.
the concept with social dance is if I got up and just started moving my body in response to hearing music, that is not choreography. That is dance, no question. But that is not, well, it may not, in my case, it may not be dance, but but it clearly is not choreography, because in some sense it's unplanned.
And that's kind of what the Copyright Office says. They define it as the composition and arrangement, sounds like a musical term, of a related series of dance movements and patterns organized into a coherent whole. So there's, like you said, there's a plan. There's something going on here.
Yep.
You kind of get into sort of the fundamental question of how do we create things. Like I saw that Get Back special in the Beatles, and you see Paul McCartney sit down with a guitar and just start jamming on an A major chord. And after about a minute and a half of doing that, you start to hear a song come out of it that you recognize that winds up on that album. So, but that's not how John Lennon wrote. He would go home and work by himself with nobody around and just come in with a complete composition when he's done. So it kind of raises the question, does it matter how people create and write and whether something's protectable or not?
Well, it does kind of feel like they're saying, a little bit it does.
Yeah, at least for choreography it does.
For choreography it does. But again, I think part of the thing it really comes down to is it's the how many variables are you controlling? And to me, that feels like so much of this. And I think maybe this is, a little bit of my physics and, my studies of chaos at one point in time, background coming in. The more variables that we can put into it, the more likely it's choreography. Similarly, the more of those variables that are copied, the more likely it is infringement. So to me, it really feels like we've got the court kind of looking at this thing and saying, how many variables are there and where is the line? And we can look at it and say, if you copy just one variable, okay, you take a step forward with your left foot. That's not copyrightable. That's a dance step. If I say you take a step forward with your left foot exactly 12 and a half inches, and exactly this speed, while simultaneously doing these other 15 things. It
with your body in
like
a certain posture,
Yeah, even though the fundamental step is still the same thing, and I'm still doing the same thing, I've got all these other variables which I'm just considering and carrying out, even though the actual act of taking the step, in many respects, is the same in both cases.
We'll get into a little bit of how that works, and this is where the appeals court said that the district court applied the law wrong. And this is also important and widely misunderstood. The court says here, the Copyright Act does not prohibit all copying. There is some copying you are allowed to do. For example, and they quote a case here, that the Copyright Act exists to encourage others to build freely upon the ideas and information conveyed by a work. So you can copy the ideas and information as long as you don't copy the protectable elements of the work itself.
I always find that kind of interesting since, in patent it's enshrined as design around, but yet derivative work is an infringement under copyright.
Yes. So they go on to apply what's called the unlawful appropriation standard, which has two parts. One, did you copy anything at all? If you didn't actually copy it, even if it's identical, you didn't infringe. In other words, originality is a complete defense to copying because, as we often say, copyright is about copying. So if I never saw your work and the similarities are purely coincidental, fine, I didn't copy anything.
The hard part with it is proving.
Because it's never direct evidence, right? So we usually get indirect evidence there by saying, well, look, these two works are too similar for the similarities to be purely coincidental. And in this case, I don't think copying was denied. It looks like that was conceded. The second part, though, is unlawful appropriation, which itself has two different parts. One is what's called the extrinsic test, which is if we zoom in and just look at the protectable parts of the work, because every work has parts that are not protected. If we look at just the protectable elements, were those copied? And then the second part is the intrinsic test. You zoom out and say, setting all that aside, looking at the work as a whole, how would normal people feel about this? Does it look like it's the same? That second test is not an issue here. That's what the jury does in a copyright case. But the extrinsic test, where we look at the constituent elements that are protectable under law, that's what the court looks at here. And that's what they're saying the district court didn't look at correctly because they broke it down into a series of poses. And the Ninth Circuit said, well, that's not right. That's like taking a song and saying, well, if I look at just the individual notes, then you don't own anything, which is, of course, true. But if that's the case, then do we even have copyrights?
What do you have in conjunction with the nature of these basic things? You can, in some sense, it's a level of what level do you zoom in at? If you zoom in too close, everything is this just unprotectable element.
Basically, once I edit out all the copyrightable elements, there's no copyrightable elements left. And they gave the example of how the way, and this is true for virtually all types of art, more true for some than others, but they pointed out something that is near and dear to me and Kirk, which is that in cases where the individual elements are not separately protectable, the copyright still exists in what we call the selection and arrangement of those individual unprotected elements.
And anybody who's listening to this podcast has probably heard us refer to selection and arrangement before?
Yes. Also, sometimes sequence, structure, and organization in software. We'll get into that in a second. But the court points out, some things like photography, for example, you can't copyright facts. What something looks like is just a fact. So if I take a picture of something, what is the authorship? What is the creativity that went into that? And depending on how skilled I am as a photographer, there may or may not be anything. If I just raise my camera up on default settings and quickly snap a picture of something without any kind of framing or selection, there may be no copyright in that photograph. But for skilled photographers, which is not me, there are various creative choices that you have to make. What is the field depth? What is the lighting? What is the pose? What is the subject matter? What is the camera angle? What time of day do you take the picture? A lot goes into that. None of those things by themselves are protectable. Just like in music, nobody owns a chord sequence or a pitch or a tempo or a genre. But you pick out the things you want to make your song, you put it all together, and the gestalt is a copyrightable work.
Well, let's take the quick snapshot of the idea that I just pull my phone out and take a quick snapshot out the window. That there's a lot of argument that I made no choices in the conjunction with doing that. Every choice I made was done by the computer, everything else. But if a skilled photographer then comes along and attempts to purposely recreate that snapshot, that more than likely requires them to control a lot of variables. Mm-hmm. They have to take it at the same time that I took it. They have to position the camera in a similar position to where I took it. They have to make sure that their camera behaves the same way my, digital camera doing its own thing did at that point in time. That particular photograph, even though I didn't control those variables on purpose, those variables were controlled and selected around it. So when we look at it as a gestalt, yes, that picture is protectable, even if it's an undesigned work. Because I took it as a human being, I did put some control over those, even to the extent I didn't consciously take the control. And interestingly, this is one of those things they got into originally with the potential copyrightability of photographs.
Which wasn't clear.
When
photography was invented.
Because as people commented, it's a recreation of the world.
You're just capturing facts. You're capturing the world as it looked at that time. Nobody owns that.
And there was a recognition that do have to make some artistic choices that are made. How many variables are there? How many variables are being copied?
How many variables are there to control, and how many did you control?
Yep.
Okay, so that's kind of how the court looked at this. They said, look, an individual standalone dance movement like a plie, it's like an idea. It's like a note. And for the district court to break this down and say, well, look, it was just a bunch of individual poses, it's like taking a song and saying, well, just a bunch of individual notes. And yeah, you copied those 8 notes in sequence, but so what? And they actually analogized to the Led Zeppelin case, which I think we talked about before. I think I did a whole episode on this during the pandemic. Yeah. So the Led Zeppelin case, Led Zeppelin was accused of copying, the Stairway to Heaven, probably the most famous rock ballad of all time. If you've never heard it,
you've heard it.
First of all, you've heard it. But go listen to it. The first 12 seconds, you're like, oh yeah, that song. So they were accused of copying that from another composition called Taurus by the late Randy Wolf. That case also was in front of the Ninth Circuit. And they applied a similar type of analysis. They, Led Zeppelin's lawyers argued that, well, look, the elements of this work are not protectable. You've got like a descending line cliche. You've got an A minor key signature. You've got a light tempo. You don't own any of that stuff. To which the Wolf lawyers said, well, yeah, that's true, but that's not the point. It's sequence selection and organization. It's picking out those individual components and putting them together the way that we did. And it's worth pointing out, that case went to the jury, whereas this case did not. So the Ninth Circuit in that case said, yep, that's good enough. Send it to the jury. Now they found no substantial similarity and therefore no infringement. And that case was over. But that's what they're saying the error was here. The district court should have let it go forward because there's enough there.
But it has the question of, how many variables were done here. What the court is kind of looking at is they said, the district court said that there are each individual variable, there may be 5, there may be 6 of them, whatever you want to say behind it, but each individual variable is something that is a known value, so therefore you have nothing. Whereas the court here looks at it and says, no, you have to look at the fact and say 6 were copied, 10 were copied, however many it is. That's enough because it's not just one, or maybe even just 2, where you have to put them together.
Yeah, Hanagami says there's body position, body shape, body actions, transitions, the use of space, timing, pauses, energy, canon, motif, contrast, and repetition. I don't even know half the stuff when I learned a lot about dance just from reading this case.
Well, and that's saying sort of all these things. what really the court says in this is you can't say that all of these things are unprotectable, because in combination they are. Let a jury decide whether or not it's infringed, because that's what a jury's for. And if the jury says, no, it's not infringed, well, that's okay. But you can't not let them say it.
And they specifically analogize to music. In fact, they say, these are more discrete and technical elements, conceptually similar to elements we recognize in other copyright contexts, particularly music, where you've got melody, harmony, rhythm, pitch, tempo, phrasing, structure, chord progressions, and lyrics. So it's the same basic concept. And Kirk and I were talking, and then the takeaway is that they said, you did that wrong, court, go back, and basically wave this through. We'll deal with all these issues in discovery and see if there's really a problem.
But it's that. Again, this is descriptive. Here's what it is. But you kind of look at it and say, is each of these elements, unique? In the end, well, yes, this is what the court's kind of looking at and saying is, we can't just say the fact that it has a crescendo here. Crescendo,
you don't infringe by copying a crescendo, even in that one spot. You had to kind of put all the pieces together. And we were talking about this in the context of a couple things. One, the Google v. Oracle case, where Kirk, I'll try to link that episode in the show notes if I remember to, but if you read that one, we both have commented repeatedly, it's weird that was a sequence, structure, and organization copyright, a selection and arrangement copyright. The claim was not that math.cosine is copyrighted. It clearly isn't. It was that the entire API as an organized whole is copyrighted. That's where the creativity goes into that. And it's the implementing code that's uninteresting. I mean, everybody knows how to calculate a cosine. That's not hard. But that aspect of the case played virtually no role in the Supreme Court's decision. It went to a jury, ultimately, although the Supreme Court overturned it.
And again, I think the interesting thing we bump into with this, and maybe it's a real follow-up from the Google versus Oracle, how much are we now starting to see that this is everything in copyright law?
Yeah.
So really what copyright law is falling down to is, we recognize the fact that all of copyright is effectively built out of foundational blocks.
Yes. Did you invent the English language we're using to record this podcast? No.
But we have a copyright in the recorded version of this podcast. And so, those are the kind of things where and what we're really sort of seeing is a court's starting to struggle more with where is the line between what is a word, a letter, a short phrase, something known in conjunction with it versus the work as a whole. What matters is this arrangement of terms, this common arrangement of terms. I think it's important to mention, since we're going to kind of move away from the case now at this point in time, the circuit court did overturn this. So they did say, yes, the district court did this wrong, but they didn't find for the other side.
Which is correct, right? Because they don't have the discovery record. It hasn't been prepared yet. They're just saying you shouldn't have dismissed at this early of a phase. The case needs to go on at least a little bit further. Now, maybe it still does get dismissed once we get into this. Who knows? But the point is, you shouldn't dismiss it at this phase.
It may also settle. The whole point of what you're supposed to do district court is you are going to get rid of the case only if everything they said was true, they had to lose. What we find is they didn't have to lose. Now, the answer may be after you have more information.
They still lose.
But that doesn't mean that you have. So the real key behind it, I think this is one of those things that gets misrepresented. A lot of times people talk about cases. The choreographer in this case has not won.
I hear people say things like, he won on appeal. Well, he won the appeal of the grant of a motion to dismiss, but he has not won the underlying lawsuit yet. It's barely started.
Yeah, it's barely started. They haven't even tried the lawsuit, and that's basically what the appeals court did, is they said, no, go back and actually let both sides argue about this for a little bit.
We also, related to Google v. Oracle, that was a fair use decision, and Kirk and I were talking before we sat down to record that this aspect of all copyright works being gestalt, and it's related also to the vocabulary of expression, which differs in terms of its size with different types of work. And we thought it was not coincidental that the court here focused on the parallels between choreography and music, because both have very limited vocabularies of expression. Music is limited by the laws of physics, basically. It's an acoustic science, and there's only so many ways you can form sounds. The wavelengths, if they don't line up, sound bad together. Octaves are a natural phenomenon. It's not something somebody invented. Likewise, thirds and fifths and these other things are wavelengths harmonizing. So while there are lots of ways to write music, there are only so many ways to write appealing music that don't make people's hair stand on end. And of course, the range of audible music we can actually hear is limited, and the range within that range that is pleasant is even more limited. So music is limited, and then likewise choreography. We're talking about ways to move the human body. Well, your biomechanics dictate a lot of that.
Yeah.
Okay, you can't jump 12 feet in the air, so you can't do that.
Someone Biles might be able to.
Your elbows only bend a certain way, and you also have the laws of gravity that affect, how far back you can bend, So all these things have inherent limitations, which may be why we see courts being more reluctant to aggressively enforce copyrights, notwithstanding the denial or the reversal of the motion to dismiss here. But we do see courts, we think, less willing to aggressively enforce copyrights on these types of works, relying more on the selection and arrangement aspect of it, and I think applying fair use more broadly, which makes sense because one of the fair use factors, which we often joke virtually never matters, is the nature of the work infringed. Well, if the nature of the work infringed is, for example, an API, you might be more generous with fair use on grounds that it's not entitled to much protection.
Yeah, and I think, you look at it and say that may be part of the reason why Google wasn't as focused on this, the factors of arrangement, is because, there was only so many ways it could be arranged, and that's kind of what they say. They say because this is factual information.
Yeah.
There's only, it's mathematical. There's only so many ways it can be arranged. So we're going to head and again, I'm going to drop back to my analogy again. There's only so many ways to put the variables into it. If you talk about, how many ways can we collect letters together? Well, there's 26 different letters, not including numbers and symbols and everything else. So there's huge number. Once we get to, just a few thousand letters connected, we start to get enormous numbers of things, near incalculable numbers of things. Whereas if we start saying with music, there's only, there's not necessarily 26 different waveforms available.
No, we have 12 notes in the Western canon?
Yeah. And so, those are the kind of things I think you bump into is it's this question of essentially what is the world in which you can work, recognizing that the world of sound is much bigger than the world of audible sound, which is bigger than the world of enjoyable sound, which is bigger than the world of sound, which is rock music.
Which to your point, that world defines what the available variables are to manipulate and creating things. And the fewer of those that there are, the more the works are going to tend to look and sound and feel similar. But you can't be too aggressive about enforcing copyrights on small chunks of that, because otherwise you never create anything. Whereas with the written word, we were talking before, I want to describe a 1968 Pontiac sitting in my driveway. There's a lot of ways to describe that car. Now, some of them are going to be similar. I'm probably going to talk about the color, the wheels, the styling, probably something nostalgic. So the fact that two different descriptions have those things in common, that might be sans affaire. Those are not copyrightable elements. But if I just directly cut and paste, if two people write completely identical descriptions of that car, it's probably not a coincidence. Somebody probably copied somebody else, and we're more likely to find infringement because there is so much variability available there due to the inherent nature of written language.
I also think that this is one of the things where the court in this case, and particularly the circuit court in this case, is very cautious of sort of looking at it and saying, when we say what is choreography, we can't say it's too few variables. And I think that's kind of what they're admonishing the district court for here, is saying it's not just steps. It does involve body movement and things like that. And in some sense, it's the thing the district court got wrong, where they said, we're going to consider these other elements, like the dancers are different. Yes. They're not human. They're animated. They're, things like that. And the court's always saying, no, those aren't elements of the choreography.
That's
those
not
are
part of the copyright.
Video.
Yeah.
So we're not talking about copyright in the video. We're talking about elements of the choreography. So the fact that these things are different doesn't matter because those aren't elements of it. These things are inside it. So we're starting to see, and I think this case being a choreography case, this is an important thing and part of the reason we wanted to focus on it. We didn't really have a good discussion of what is choreography. This is probably the best discussion we've ever gotten of this is what it means to get a copyright in choreography. But even this isn't real clear yet because they've sort of just said, we know that copying this much is not way too little. Yeah. Do they copy arm movements? Do they copy, what exactly is copying?
So if you copy the steps, we have different upper body movements. Is that enough?
And
one way to think about the difference between the choreography and the video may be that, I've seen this in the compendium, you can submit a choreography copyright using, there's a whole nomenclature for it, but like schematics for dance steps. You've seen those before where they got the footprints on the ground. You can submit that as the definition of your choreography. And then somebody else's video or video game could still infringe it if you have somebody copying those movements. So it's kind of a weird thing, and it falls into the category of things that, generally speaking, our IP laws don't like to protect, which is sort of the basic aspects of life. We don't like to protect food. We don't like to protect clothing, housing, and moving your body, or things that we try to steer clear from. So the choreography copyright is probably ultimately going to be relatively narrow in scope, and so infringing it, I would not be surprised if once we get into discovery, Epic still wins.
Yeah, I think that's one of the things we can look at is it's really, I think the key takeaway from this case and what we have for it is what it is. There has been no decision here as to whether or not this infringes. There really hasn't been. What we've had is a decision that said we haven't figured that out yet.
Yeah.
And that's a sort of important distinction to make because I think a lot of people have looked at this and said, no, they've said it doesn't, or they looked at it and said, yes, it does. And the answer is no, both those positions are incorrect.
Which again, contrasting with the Led Zeppelin case where the court let it go to the jury decided non-infringement, and that was the end of it.
Yep.
We got to that intrinsic part of the test where they said, no, look, I know they're not experts, but these aren't the same song. It's just that simple.
I also wonder about how much we're going to see more of this because of stuff like, again, generative AI. What we've seen bounce around a little bit because of this is the Copyright Office looking at it and saying, hey, if we have generative AI, we have these algorithms. They are algorithms underlying them. I understand there's some chaotic elements in them and stuff like that are generating text. Is that text in any way creative? And the Copyright Office kind of said no. They're kind of looking at it and saying that's because ultimately the way the words are put together is algorithmic. And that's where we're then bumping into the question of, well, how does a human put together? And that's where we're getting at these fundamental questions of creativity.
Well, we have this analogy too of, okay, well, so the AI is assembling a gestalt the same way that a person would, right? At least conceptually. So if the elements that it picks out to assemble are elements that were sequenced and arranged and selected by a human being, why wouldn't you get a copyright to the selection and arrangement at least, if perhaps not to the specific expression? Is that enough? And then you kind of get into some really weird issues. I think with writing, that will be harder to assert. The courts are more interested in literal copying with writing than copying broad things like plot and character, although we do see they sometimes will enforce character. And then likewise with images. Just the fact that two images have the same objects represented, maybe even in a similar spatial relationship, often isn't enough.
Yeah. I think part of what we're also seeing with this, quite frankly, is I think the reason choreography is going to become more important is because our ability to animate human forms has reached the point that they move like humans. If you think about it, just, 20, 30 years ago, we really couldn't do this. Movement on screen of any kind of animated image of humans looked animated. Yes, it had human movements, but, Super Mario does not move like a normal human. That kind of thing. Sort of, that's our ability to do the kind of animation that allows us to effectively copy the movement of the human body in something that's a choreographed dance type of thing has hit the level of doing this. Whereas if we're talking about it purely as dance versus dance, you really bump into the two dancers can obviously readily do exactly the same dance with incredibly different interpretations. Mm-hmm. To the point that you can look at it and say, no, the choreography is not infringed, even though they're literally doing the same dance. They're taking the same instructions and doing the same thing, behind it. And so I think you had fewer cases because there was kind of a recognition that the choreographer and the dancer necessarily impose their own level. Whereas a computer doesn't. A computer is told to do what it is told to do in the presentation of an animated figure. So I think that's one of the other things we're going to see here is we're going to start seeing stuff go as these computers are getting more powerful. We're starting to see these questions arise of where are the creative decisions versus where is this a literal reproduction of what we told it to do.
So one final thought, and then we'll wrap this up. So how come World of Warcraft, which has a lot of dance, some of them much longer than 2 seconds, why have they not gotten in trouble?
Yeah, and the answer is we don't know. I think that's they obviously could be licensed. We don't know what the question is with it there.
It may also be that there's no damages, right?
Maybe no damages.
It could be that the choreography was not registered in advance. Now, so the Saturday Night Live, the Chris Farley routine where he does the Chippendales dance, it's possible that NBC has registered that work, but did they register the choreography in it? And if they didn't do that before World of Warcraft came out, registering it afterwards does not get you access to statutory damages. Plus, even if it did, the damages are per work. Only one work was infringed. Is it worth going after even the statutory, even the willful maximum of $150,000? Is it really worth your while?
Yeah, and that may be part of it is definitely the damages question. Quite frankly, part of it may also be it wasn't seen as an infringement at the time it originally came out, and now it's too late.
Although under Petrella, which who knows if that's still good, it may be. And another possibility is just that how do you articulate the damages? World of Warcraft is a subscription service, and these dance moves are one tiny part of it. Even if you've got, say, 100 million subscribers paying $20 a month, how do you go into that and say, well, people are subscribing because of these dance moves, and so we're entitled to what in damages?
Yeah,
so I think it's a really speculative case. It's hard to make.
It's one of these questions where you get into it, and lawyers will oftentimes say it doesn't matter what happened, it matters what you can prove.
Yeah.
And I think that's that's very true in the World of Warcraft case is when we look at this, most of what we'd say the reason this hasn't been brought is because what you can prove is really not clear. We don't know what happened, and it's hard to know what happened, for real. They may very well have copied them. They almost certainly did copy them.
And they've been a fair use. It's a good fair use argument.
Yeah. But we don't necessarily know what you can prove. In this case, in some sense, like you sort of said, because this is a motion to dismiss, the question as to whether or not it was copied is not questioned. They didn't challenge whether or not he said it was copied. And so the court has to accept it was copied.
Yeah, and they said even if it was.
At this procedural stance.
Yeah, they said even if it was, we didn't copy anything that you actually can enforce.
Yeah, and so, you have those kind of differences there. So again, this is an interesting case. It's something we want to talk about a little bit from procedure. We want to talk about it because it is the Fortnite dance moves. Choreography is kind of unique. It is Fortnite, which we don't talk about since, again, neither one of us really play it. But it is one of those things that I think it's an intriguing case and an interesting area. Geek Law, we're going to see much more of in the near future.
Definitely. All right, so we've got some more things coming up. We're looking into a possible patent issue involving Nintendo. And then our friend Ed from Grand Rapids has thrown a bunch of issues at the wall to see what sticks. I haven't gone through it all yet, but we're going to see if we can get to the thing. Something involving a WordPress. We're going to figure out what that is. So we've got hopefully some more content coming up here before the end of the year. So look forward to that. We also have a bunch of Star Wars content to get to. I don't think we talked about Andor or Ahsoka or a bunch of other things. So that's all coming up on your Lawyer's Guide to the Galaxy podcast feed. So look forward to that. But that's all for this time. We'll see you next time. Lauren, play us out.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. This podcast was produced and recorded in St. Louis, Missouri.